Thank you all for joining us today. I am Eileen Villa-Golden, and I am the program assistant here at the Maricopa Sbdc, and I will be the facilitator for today's webinar. I will be monitoring the chat throughout the webinar, so if you have any questions, please put your questions in the Q&A section, so that way they do not get lost in the chat. And now we will be having our Sbdc business analyst, Farina, here to give us an overview of the Sbdc.
Good morning, everybody, and welcome, and thank you for joining us this morning. We've got an exciting program for you and some really terrific speakers. So if you're in the webinar for the Intellectual Property 101, you are in the right place. I'm going to just tell you a little bit about what we're going to talk about today, what our speakers are going to talk about with regard to intellectual property. We're going to cover topics such as what is the USPTO and the resources available, an overview of intellectual property, the types of patents, trademarks, copyrights, and trade secrets, why innovators and entrepreneurs should consider protecting their IP, and how to get started in protecting your intellectual property. And this webinar is brought to you by the Maricopa Sbdc in conjunction with the USPTO. So this is me. For those of you I don't know, I'm Farina, and I am a business analyst here at the Sbdc. I work in the area of technology commercialization, and I often deal with clients who are building businesses that are foundationally based on intellectual property. In general, here are some of the Sbdc services that are available to you and some of our expertise. We're part of the America's Sbdc network. The Sbdc is a national program. We're not the SBA. We are partially funded by the SBA and matched by the Maricopa Community College District here in Maricopa County. There are SbdCs all over the country, starting at the state level and broken down by region. So there are resources available to all of our clients throughout the country should they happen to move different locales. The Arizona network is based upon 10 different geographical centers. Again, we're in the Maricopa Center, so we cover everybody in Maricopa. But you can find Sbdc counselors in Prescott, in Show Low, in Flagstaff, in Tucson, etc. Some of the areas that we our expertise, we did, and this is at the top of the list, so we're going to have to change this slide at some point. Disaster loan assistance. 2 years ago, that wasn't even on the list, but we did a lot of disaster loan assistance with regard to PPP and EIDL. That's kind of come and gone to a certain extent, but there's still some issues with those programs. A lot of what we do also is lender readiness. So, our hook into the SBA is we can help you with SBA preparation for loans. I think somebody needs to mute, please. And so we can help with loan packages if you're looking for a commercial loan to expand your business. We can do financial reviews. We have marketing expertise, buying, selling businesses, exit strategies, some manufacturing, technology commercialization, which is my area. We have some specialists in export and international trade. And then we have another group called Ptrc that handles government contracting. So if you are somebody who's been in business for a while and thinks they want to start to pursue either federal, state, or local government contracts, that's another service that's available to you through the Sbdc and our Ptrc group. So we're going to start today getting to know the audience just a little bit better. We're going to put up a poll, and we want to tell us about if you filed a patent of some sort. So we've got some choices. Eileen will flash them on the screen, and then we'll get the results. And this will help us understand a little bit about who's in the audience, and maybe even kind of tailor our presentation to. It says I can't vote. Okay, I won't vote. So please fill that in. Take a quick second, and we'll flash the results, and then we'll get moving.
Just a couple more seconds for the poll.
Okay, so look at this, interesting. So we've got a lot of folks in the audience that need an introduction. They're just learning about intellectual property, and I think they're in the right place. A lot of those folks probably have some ideas that are patentable, see if they're patentable, and they're trying to figure it out. And so that's looks like the majority. We have some who provide, who have filed a provisional, and then one has been issued a patent. So interesting. Okay, good. I think that's a good mixture. Okay, so let me move on. Okay, our featured guest speaker today, one of our featured guest speakers is Jera Edwards from the USPTO. She is the Acting Assistant Regional Director and Supervising Patent Examiner for the Western Regional United States Patent and Trademark Office. So we're really very fortunate to have Jera and her deep expertise in providing this presentation. She's the Acting Assistant Regional Director, as I mentioned, and she's a supervisory patent examiner in TC 3700. She manages a team of examiners. She was a practicing attorney specializing in patent prosecution for many years, and she joined the USPTO in 2010. She's got a BS in physics from the University of Maryland, Baltimore County, a JD from the University of Michigan Law School. I'll let Jera introduce herself as we get going here. She can give you some more information on her background. The second speaker we have is Kori Tueller. Some of you may know her. She's local here. She is the Assistant Administrator for the Patent and Trademark Librarian here at the Arizona Patent and Trademark Resource Center. She serves as the Patent and Trademark Librarian for Arizona and manages the Reading Arizona ebook platform and engages in outreach, connecting the community. So this is a good opportunity for Kori to be able to let you know what other additional resources are available locally here in Arizona. So with that, I will turn this over to Jera for her presentation. And again, please put your questions in the chat.
Well, thank you, Lou, for that introduction. That certainly hit all the highlights of my background. So the only other thing, let's see, I'll share.
Oh, I need to stop sharing. There you go.
Okay, so I'll just mention that. So the United States Patent and Trademark Office, we have 5 offices. We have a headquarters in Alexandria, Virginia, and then we have 4 satellite offices around the country. So I'm located in the office in San Jose, California. That's our Western region office. And we provide services to basically all the states that touch the Pacific, as well as Nevada and Arizona. And so very pleased to be here. I'm glad that many of you are here to learn more about intellectual property. The slides we're going to see today are part of a series we have called Path to a Patent, which is a quarterly series of, I think, about 6 to 8 seminars that build, one upon the other. And this will give you a good idea of, the type of information that we provide at a sort of a higher level, an introductory level. So this should be good information for a lot of you. And of course, we have our notice that, this is not legal advice, just for informational purposes. So just some background stats, and this is kind of a long presentation. I may, breeze through some of these slides, but you can see here we're a pretty large organization, over 12,000 employees, around 8,000 or so patent examiners, and we are divided, as Lou mentioned, my background is in physics. So when I started as an examiner, I actually started in navigation and vehicle systems, something, sort of closer to my background. Currently, I manage in medical prosthetics. So there is some, fluidity throughout the office, but examiners are basically organized by expertise. And they are the first line that receives your applications. does a search around it and sends out communications regarding the applications. We also have trademark attorneys, not nearly as many, around over 600 trademark attorneys. And then there are patent trial and appeal board judges and other team members, as well as trademark trial and appeal board members. So you can see thousands of applications filed, thousands are issued, same for trademarks. We're a pretty busy office. So this slide has a basic overview of the steps for applying, receiving, and maintaining your patent. And so we'll go through some aspects of this process in this presentation. So just starting at the very beginning, right? Starting with the basics. What is intellectual property? Well, we all understand, real property. You've got, your home and your picket fence, and that fence kind of defines where the boundaries of that property are, right? So you're not going to go trespassing over that fence unless you're invited or, you have a reason to be there. Maybe if the door is open, welcoming you, you might go in, but otherwise that fence kind of says, keep out. This is my boundary. You're not necessarily welcome to come in here. Intellectual property is a little bit different. It doesn't necessarily give you a right to do something, a right to necessarily practice what's in your patent, but it does have something in common with real property in the sense of you have the right to keep others out, right? So to keep others from doing this process or making, this apparatus that you have patent protection for. So there's some parallels that we can make, but it is conceptually a little bit different. So that first step, determining the type of IP protection you need, there actually are quite a few different types. So we've talked a little bit about patent protection, and patent protection is for new and inventive ideas, but really the application of new and inventive ideas. The ideas themselves aren't really something that you would patent, but if you can apply that idea to maybe, make a process, improve a process or make a better product, then that's ultimately what you would be applying for patent protection for. Trademarks, on the other hand, identify the origin of goods or services so that if there's a certain quality associated with a particular group that, makes that product, you can ensure you're always getting that, quality product from that manufacturer, that company. And so we use trademarks to identify those goods that are associated with certain producers. Copyright is more for creative expression. So the first thing I think that comes to mind for a lot of people is music. Songs can be copyrighted. Books can be copyrighted, literature, those sorts of things that are creative expressions, excuse me, are generally protected by copyright. And then we have trade secrets. So here there's some examples of, Coca-Cola and KFC, and that's, the secret recipes that you don't want to get out there, because that would be really hard to enforce, to say, no one can put these 7 spices right in their own kitchen, in their own home, or, that sort of thing. You might want to keep that as a trade secret, because otherwise there may really be no way to enforce, preventing others from doing that thing. So there's just some more examples of companies with trade secrets. So that's one, determination you'll have to make depending on, what sort of business, what sort of product you may be bringing to market, right? Is it better to pursue something like patent protection, where ultimately your sort of discovery or your method will become public, or to keep it as a trade secret? And this slide just mentions certain ways that you can lose a trade secret. So just to keep that in mind, sort of early in the process, right? So failure to take adequate steps to prevent disclosure, those sorts of things you'd have to be careful of with trade secrets. And again, I'm not going to get too much in detail with that. This is sort of a more general overview, but just to let you know, there are certainly some concerns that you want to keep in mind. And that symbol, is recognized for copyright protection. And again, this is sort of showing some examples of things that you can copyright: songs, books, movies, sculptures. Titles, I believe, are not copyrightable, but the novel or the movie itself would be protectable. And there's another presentation we have that highlights the fact that the Statue of Liberty actually, it wasn't copyrighted, it was patented, but the Statue of Liberty was originally under a design patent. So sculptures actually can be protected a couple of different ways, one of them being copyright. And so the Library of Congress is actually the agency that administers copyrights. And as it mentions here, original works of authorship, including literary, dramatic, musical, etc. And the term for a copyright is the author's life plus 70 years. And you can find more information at copyright.gov. So these are symbols related to trademarks that may look familiar. One type of trademark is called a common law trademark. And that's one that's, being used, maybe has been used for years, but has not been registered with the Patent and Trademark Office. And, without registering, that may limit that mark to certain geographic areas. And so, there may be sort of a more limited enforcement with a common law trademark. And this last note is just that US is a first to use country, meaning that, if you are out there selling your goods and they have your, label on there, maybe you have, if you're selling some sort of, spaghetti sauce, so you have your picture on there, on your spaghetti sauce jar, and you're out there selling it. If you're the first one to do that, then you're recognized as having that common law trademark. Most countries, however, are first to file. So there are some differences, certainly between different countries. So there are many advantages to registering the trademark, public notice, ability to bring an action in federal court, having it listed in the patent and trademark databases, recording it with customs to prevent importation of infringing goods, and just having additional resources for enforcement and protection. And some common trademarks that we're all probably pretty familiar with: Starbucks, Nike, Target. And this is noting that trademarks can be words, and they can also be designs. And often they're, a combination of both. You can also have non-traditional trademarks like colors. I think that first one is Tiffany's jewelry box, UPS, John Deere with the very characteristic green and yellow. And other non-traditional trademarks include scents. So Play-Doh. I'm not sure that Verizon has a scent, but these are just, just some others. Groovy Grape certainly has a scent. I'm gonna have to look into why Verizon is on this slide. I'm actually not sure. Other non-traditional trademarks: sounds, NBC. Of course, if I try to sing that, it's going to sound awful, but we know not Play-Doh, Pillsbury has a giggle, characteristic giggle, that sort of thing. And then there's also trade dress. So there's quite a bit of different, intellectual property that can be pursued. So this is showing some examples of trade dress. So I'm going to skip through the trademark fees. They're all posted, you know, on the USPTO website and other places you can find out about the fees. They do change every now and then, but that gives you sort of a ballpark of what you can expect for an application fee and so forth. So this is, you know, sort of more my area of expertise is patents. And this slide is just pointing out that, you know, a patent grants a right to an inventor to exclude others. And that's that second bullet point here, you know, to exclude others from making, using, offering for sale, or selling the invention. So you'll notice it doesn't say that the US government gives the right to the inventor to make, you know, the invention themselves or to sell the invention. It's actually not that type of a right. What it does is it excludes others from doing so. And that may sound a little strange, but sometimes with certain inventions, they may be inventions where in order to actually practice the invention, you might have to license another patent because it, you know, you came up with an improvement on a process, but that process maybe uses a certain apparatus, and that apparatus is also protected by a patent. So that's why sometimes you might get it, you know, get patent protection for something that you may not necessarily be able to do without, you know, doing some other sort of legal, you know, making sure there's some other legal agreements in place and that sort of thing. But the real benefit is that by excluding others, at least you're able to reap the benefits, you know, of selling that invention or licensing that invention for a certain period of time. And so as the slide mentioned, it's a limited time period, 20 years. Generally, there's different time periods for different types of patents, but for that period of time, you exclusively would, you know, be able to exercise that right and exclude others from doing so. And the last bullet point is mentioning that, you know, this right is being given in exchange for public disclosure. So we talked earlier about trade secrets for things that you know, maybe are difficult to enforce. And so you want to just make sure that that knowledge doesn't get out to the public. Well, with patents, the whole point is that that knowledge will be given to the public. And so in exchange for that, you know, time period where you can exclude others from doing, making or selling your invention, at the end of that time period, it basically is handed over to the public. And the public can, you know, freely use that knowledge and information. So this is asking, you know, why get a patent? If you've ever seen the show Shark Tank, when people are looking for funding for their businesses, often the question is, you know, do you have a patent? Have you applied for a patent? And that it can be very helpful in, you know, getting you know, funding, gaining entry to the market, using it as a marketing tool to promote unique aspects, and of course, selling or licensing your company that's, you know, based on a product or your products. Certainly, having a patent can help with those things. So the next big step is to determine if your invention is patentable. You know, as we noted before, you know, some things would be protected by copyright, some by trademark. Mere ideas aren't really patentable. They have to be sort of applications of ideas. So we're going to take a look at, you know, some of the criteria for that. So inventions that are patentable. So this again is, you know, some more sort of legal framework for the basis of patent law. So anyone who invents or discovers a new and useful process, machine, manufacture, or composition of matter. Those are sort of the four categories of things that are patentable. And you know, just sort of in more practical terms, so what can be patented? So a process can be patented, a method of doing something, a machine, and really that includes, you know, an apparatus or what we might think of as like a product, an article of manufacture. So again, that's sort of different apparatus, like you know, anything from, you know, a toy to a vehicle to some computerized, you know, device, composition of matter. So for certain chemical compositions, and especially in the area of drugs and pharmaceuticals, those can be patented. Then, of course, improvements on any of the above can be patented. And there are also what we call design patents. Sorry, little interruption there. So ornamental design of an article of manufacture refers to design patents. The bullet points above refer to utility patents. So you'll hear those terms used to differentiate the two. And the ornamental design is more how, you know, how that device looks rather than how it functions, what it does. So there's patent protection available for that. And that's why I think I mentioned the Statute of Liberty actually was covered by a design patent originally. And then there are also plant patents for asexually reproduced plant varieties. My favorite of which is the Haas avocado, because I love guacamole. So, so basically the three types of patents are utility patents for, you know, what something does or how it operates, design patents for how something looks, and then plant patents. So what cannot be patented? So we talked before about, you know, literary, dramatic, musical works, that's copyright. But also, you know, laws of nature, you know, the law of, you know, gravity, or E equals MC squared, right? These are not things that can be patented. They're just laws of nature. There's not really, you know, an application of that to improve any physical system. Physical phenomenon, so transitory signals, light, you know, just in general, those sorts of things can't be patented. Also, this doesn't arise very often, but inventions which are not useful or are offensive to public morality. The only example I can think of that every once in a while we'll see an application for sort of a perpetual motion type machine where, you know, there's just, you know, no energy in and just energy out, right? That's not something really achievable yet, so that invention would not be considered useful. So to find out if your invention is patentable, you would do something similar to what patent examiners do when they first receive applications, and that is you can search to see, you know, what's out there. I mean, sometimes it may be even just a trip to the store, right? And you might see what's on the shelf. Maybe you've you know, invented a certain type of cooking utensil for you know, use with I don't know, I'm on a spaghetti theme today, maybe some sort of, you know, spaghetti related utensil. Well, I mean, you could go to the Target and look at the shelves and see what's there. Oh, skipped a few slides there, sorry. Sorry about that. I don't know what direction I went. I know we did this slide, right? Okay, here we are, sorry. So, you know, you can also look to see what's out there in the real world. But generally what we do first, you know, as examiners is we'll search patent databases. So we'll look at US patents, we'll look at foreign patents, we'll also look at what we call non-patent literature. So we'll look at printed publications. That can be anything from the newspaper to you know, dissertations, magazines, anything in print, and also anything on the internet. So we do searches on Google, or, you know, if there's certain websites, we'll, you know, look through different manufacturer websites to see what products they have, that sort of thing. And this is just noting that, you know, these slides are actually part of the series that I mentioned. So part 3 of the series goes more in depth on searching and gives more detail about that. This is just, you know, sort of a higher overview. So as I mentioned before, you know, there's the 3 types of patents: the utility patents, which are for, you know, physical devices, methods for creating something, processes, and there's the statute of liberty. Design patents, or basically how something looks, what's the ornamental design of something, and then plant patents. And again, utility patents protect the function of an invention, the way it works. It's for, you know, physical devices that have you know, certain components arranged a certain way, or that operate a certain way. I think this looks like an old iPod or something, or some kind of music player. And they're valid for 20 years from the date the application is filed. So if you are granted the patent, then the protection that you receive goes from 20 years from your filing date. So one important decision to make also is what type of application to file. And there are 2 main types of applications. The first one is called a provisional application, and that's early in the process when maybe you're not ready at that point to file the full formal application, but you know you are going to, and maybe you have to you know, get some more interest, maybe apply for some funding. So you're going to have to disclose some aspects of your invention to people so that they can decide whether to support you, or, you know, sort of get your name out there. Well, what a provisional allows you to do is lock in a filing date on that invention. So you're not required to have claims, which are a really important part of the non-provisional application that we'll talk about later, but you're not required to have that part. And that's that sort of claims, are that legalese that really captures exactly what your invention is. So for provisionals, you don't have to have that. So it makes it a little bit easier to prepare that application. It's also less expensive, and it's not published, and it's not examined. So it's like a placeholder. It's saying, I have this, you know, I have this great invention. I'm not quite ready for, you know, the full application yet, but I'm going to lock in this date as my application date. And you have 1 year from that provisional filing to file the full, you know, non-provisional application that includes your claims and all the legalese and costs, you know, more to file. And that non-provisional application is actually what is published and what is examined and what would ultimately become your patent. So here's a slide with some fees. I'm not sure exactly what year, you know, these fees do change every now and then, but this gives you kind of a ballpark. And just to let you know that there are different fees for different size entities. So a large entity, you know, much larger company would pay more. A micro entity might be, you know, a solo inventor, and, you know, small entity is somewhere in between. There's specific information about what qualify, you know, what revenue and that how many employees and that sort of thing qualifies you for each category on our website, or actually here on these slides. So again, I'm not going to go through this in great detail because I think people are, you know, sort of an earlier stage at this particular meeting, but that information, is available, and you can take a look at that more specifically on our website also. We also have ways to fast track the patent. So there's, for certain fees, you can ensure that examination happens in within 12 months. You would basically get, probably that's maybe half the time that a patent that's not fast tracked might take, depending on the art. And this slide gives a little information about that. Again, that's a little down the road probably for most people in this presentation. But I'll talk a little bit about the parts of the application. So there's an abstract, which is, just a short summary of the invention. The written description, that's sort of the meat and potatoes. That's the bulk of what the application is going to include. And that's going to describe everything about, how does it work? How is it made? What materials can you use? What different options are there for the process that, maybe is disclosed? There usually are drawings. And so the drawings, especially for, if it's some kind of apparatus or machine, then there'll be several different views of, the machine and how the parts are connected. And then, so I mentioned briefly claims, but really claims are extremely important. That's really what defines your invention. And so this slide is talking about the non-provisional application, because, remember, the provisional, that initial application, does not have to have claims, but the non-provisional application that you file within a year of that provisional, that has to have one or more claims. And that's, claims are the part where people often need more assistance, maybe a patent agent or a patent attorney to help with making sure that their claims are, in the best shape possible to receive an invention. So with claims, this slide is talking about kind of how to find that happy place of not too general and not too specific. If your claims are too general, then there may be a lot of other things out there. There may be a lot of what we call prior art that those claims seem to describe, even though that's not what you were trying to describe. Because your claims are so general, your claims sound like they're describing all of those things. And so the examiner will look at that and say, well, that's not novel. There's nothing new here. So that couldn't be granted as a patent. On the other hand, if you're too specific, then maybe you could have got protection in your patent for something a little broader than what you did, which maybe would have, allowed more products to be made from that patent, or you could have made more money from that patent. So you don't want to go too specific. You want to kind of find a happy medium where your claims don't look like they're describing, a lot of prior art, but also aren't so narrow that they're really only describing, a small portion of really what you invented. So that can get a little technical and a little complicated, but that's basically the strategy for claim drafting. So there's different types of claims. This slide, it looks like it just skipped to dependent claims, but there are independent claims, and then there are dependent claims. And as you can imagine, independent claims, that's usually the first claim, and it will just say, an apparatus with, maybe listing some parts. So this slide is talking about dependent claims, and those would come after. So you can see this is starting with claim 2. And so claim 2 incorporates by reference all the limitations of the claim before it. So it's highlighting here, this is saying a headgear apparatus, as in claim 1, wherein, and then kind of adding, some more information about it. So this gives you an idea of what the claims would look like. And that's, I mentioned it's kind of this, legalese to describe your invention. but this is the type of language that you'll see in most claims. I mean, there's some variations, but this is a very common way to write claims. So filing your application, there's an online system that I think people find much easier and much faster to get information about their application, called EFS Web. And that's something that you register for on our website. There's not a whole lot to say about that. So some of the resources that we have at the office to assist with filing applications, one is the Electronic Business Center. And so there's a number there, and they can give you a lot of the basic information about, how to connect on EFS Web. There's a system called PAIR, P-A-I-R, that allows you to see your filings, and actually you can see filings from others also. Sorry, I skipped slides again. A lot of, which way did it go? Once the applications are published, in public PAIR, if you know the application number, you can pull up the file of any published patent application and look at what's in the file. You can see, sort of their application. You can see the office actions, the things that the examiner has written. So they can give you information about that. Also searching for patents. So this lists our older systems, AppFT and PatFT. We actually have a newer system now that's web-based for searching for patents, at least domestically. But again, our website and the Electronic Business Center website should have the more updated information there. But that's a good place to start with, questions about how to access our system and register for EFS Web and those resources. So this slide is going to talk a little bit about working with the examiner. So this kind of circular chart here is because patent examination is, sort of a back and forth between the applicant and the examiner. So the application is filed, and there's some preliminary checks to make sure all the parts are here. So that's that first blue box, USPTO pre-exam. And then the application goes to the examiner. So the examiner does some searching, kind of like I mentioned, looking in different databases to see, is that something that seems like it's out there? And they'll take a look, especially at your claims, and see, what they can find as far as prior art. And then they send a communication to you and say, here's this prior art that I found that your claim seems to be describing that same invention, or sometimes it's maybe a combination of teachings from, different references. They'll say, well, these two references, if you look at them together, that basically covers what's in your claims. And then you get an opportunity to respond, and you can either amend your claim. Maybe there's some other aspects of your invention you didn't originally put into your claim because you didn't want to be too specific if you didn't have to, right? That sort of triangle we were looking at of, too broad versus too narrow. So maybe now you can amend and add some more subject matter into your claims that differentiates it from that prior art. Or maybe you disagree with the examiner and you can say, no, that's different. That doesn't work the same way, and explain to them why it doesn't work the same way. And then you send that communication to the examiner. And then the examiner takes another look. They consider your arguments. Sometimes there can be what we call an interview, where you have a phone call and you talk to the examiner. But basically, there's sort of this second round of, going over that application and seeing, okay, now when we compare it to the prior art, do we still think there's, too much overlap, or is there something that really is novel? And And that's, that's sort of this little circular thing that happens here. So that happens kind of 2 or 3. So the first action is called a non-final office action. And then the second action usually is called a final office action. But even after that, there still can be some back and forth. And then, hopefully that gets to a notice of allowance. Sometimes it doesn't. And it may lead to an abandonment. Maybe there just wasn't really enough novel in that application, and that may lead to abandonment, or at least to allowance, and then the patent is granted. So what does the patent examiner do? We've talked, a lot about that. They need to read and understand the application, and that's why examiners all have technical backgrounds. The examiner searches for prior art, and I have just a funny anecdote. I was saying prior art can come from anywhere. There was one case where an examiner actually used a couple of screenshots from Seinfeld to use in part of the rejection. There was some telescoping mechanism that came out of a vehicle, and there's an episode of Seinfeld where one of the characters is trying to see around traffic, I guess, and creates this, sort of telescoping view around the car. So Sue actually took screenshots of that Seinfeld episode and used that in the office action. So really, prior art, it can come from anywhere. Usually less exciting sources, just other patents and technical journals and that sort of thing. But then, again, they look at the claims, especially, and evaluate that in view of the prior art. And then they write what we call office actions. And that's basically like, it's kind of a letter. It's saying, here are the issues that I found with the application. That can be sometimes maybe something's confusing, maybe something seems to be left off a drawing. We call those formalities. And then it gets into, here's the prior art that I found, and this is maybe why, the patent can't be granted because this prior art seems too similar to the claims. And as I mentioned, there can be interviews, because sometimes it's, especially with very technical things, it's much easier to just talk about it and make sure that everyone understands the terms the same way and that sort of thing. So we highly encourage interviews to help advance prosecution. So this is talking about some of the other, sort of what's calling them statutory hurdles, but really just concerns, to keep in mind early when you're writing the application. We've talked about, is it new? Is it non-obvious? Is it patent eligible? But also, are the claims written clearly? That's another big issue. Could a skilled technician reproduce the claimed invention based on what's in the specification? And that the specification, we talked earlier about detailed description, that's kind of that same part of the application. Because again, at the end of the 20 years, the bargain that we're making is, you get this monopoly on your patent for 20 years, but then it goes to the public. So we need to have enough information that when that time period is over, the public really can take that information and use it based on what you've disclosed. And so here's, I think this is an actual patent. So this is the front page of a patent. And you can see, kind of what that looks like. There's the drawing, there's the abstract. This one isn't showing the claims. But when we talk about the examiner searching, like you'll see some of these numbers here, these refer to a classification system that organizes the patents and the other information that we look through, so we can tell, where the examiner searched, kind of like the Dewey Decimal System for libraries. You can tell what areas the examiner looked in. This lists, some other prior art documents that were found during examination. And actually, the front of the patent always lists the examiner also. And if there's a law firm, then it'll list the law firm there too. and then maintaining your patent. So there's still, you know, even once you receive the patent, there's some work to be done, right? There's periodic fees, but you'll want to, you know, monitor and make sure that, you know, if you're seeing knockoffs, making the authorities aware and just doing your best to, you know, enforce that patent that you worked so hard to get. So here are some resources. So this is just a screenshot of USPTO.gov. It's a very user-friendly search bar. You know, so any of the topics that we mentioned, you know, if you type those in, it'll take you to pages that will help, you know, provide some resources and descriptions for those things. It's actually a really good website I found. But this lists, you know, some categories that you may want to look through sort of initially just to get more information about that whole application process. And we also have a page for, you know, startup resources. The regional offices actually give also a seminar. I think there's a seminar that we give specifically tailored towards, you know, people who are in the startup phase. But we have a lot of resources for startups, as that's a really popular topic. This is a little about stopfakes.gov, which the International Trade Administration assists in, you know, helping business owners protect and enforce their intellectual property. So they provide some information and guidance and training. So that's a good website to know, you know, sort of once you're in the enforcement sort of phase. And then I'll just go through these a little more quickly. That's a little ahead of where I think most of us are. So this is another great resource, the Inventors Assistance Center. And that's, you know, staffed with specialists from different areas, supervisors, quality assurance specialists, and they're there to just answer any questions that you have. They can direct you, you know, to the right department or help provide you some more information, you know, just get you on the right track. And they're very experienced in just talking with, you know, inventors, solo inventors, and what we call pro se, if you're pursuing your patent without an attorney or agent assistance. They can, you know, they're used to giving the type of information that people need at that stage. So just to keep in mind, they cannot provide legal advice. So for example, they can't tell you, yes, this, you know, is or is not patentable. They can't really give you legal advice of this, you know, about, you know, this definitely complies with this law or it definitely doesn't, that sort of thing. They can't actually do a search for you. And, you know, they can't, you know, specifically fill out the forms and things like that, but they can assist you with more general questions. So finding, you know, which form to use and explaining what information should go in the form, you know, just answering questions generally about policy and formatting and how to, you know, for mailing, what's required or how you would use the mail or use EFS web, that sort of thing. So that's what that slide is explaining. So PPH, so this is just another, I mentioned before, there's some ways that you can expedite prosecution. So that's just another way. That's a little ahead of sort of where we are. And that involves usually an application that's been filed in another country. I'm just going to skip through those. So here's a slide that just has, you know, compiles sort of all the resources, different phone numbers. The Pro Se Assistance Unit, so I mentioned that term before, Pro Se. That term refers to, you know, someone who's applying without the assistance of attorney. So that's without the assistance of an attorney or an agent. So that's a good number to know, sort of if you are very much in the initial stages and you haven't, hired anyone to help, but you have questions. There are different, even in office actions, there are different form paragraphs that we use that have additional information because we know it can be confusing. There's a lot of legalese. So they're more skilled in sort of breaking it down and helping you to understand the legalese in the pro se assistance unit. So that's always a good resource for solo or smaller companies. And there's patent pro bono help video, which there are many organizations that will offer free, pro bono, meaning free legal assistance. There's this also mentions law school clinic programs. Often they'll offer free or discounted assistance so that, when you do get to a point where you think, okay, well, now I do need an attorney, that may be an option where, you actually can get some assistance for free. And I think I'm pretty much to the end of the slides here, but I just want to mention we have patent and trademark resource centers, which have specially trained librarians and staff members who can help you also, with your patent searches. And I think Kori Tueller is going to talk a little more about that. But you can see we have we have one in Arizona here with a link at the bottom. So I think now I'm passing it to Lou. There may be like one more, I think one or two more. Yeah, just a couple more slides. But so that wraps that up, and I'll pass it back to Lou.
Thank you very much, Jara. That was very informative, and we certainly appreciate it. I'm going to pass it over to Kori now. And as I mentioned, Kori is the assistant administrator for the Arizona Patent and Trademark Resource Center. So we've got some local resources here and some expertise that can help you, and Kori will take you through that.
Great, thank you, Lou, and thank you, Jara. Let me call my slides up. Can everybody see my slide? Great. Yes. Perfect, thank you. So thank you, that was a really informative presentation, very helpful, and I appreciate, I always appreciate a good thorough review of intellectual property things. And I appreciate Lou and his team for allowing me a little bit of time here to highlight some of the things that you should know about Arizona's Patent and Trademark Resource Center. I know there's a lot of information that you just ingested, so my goal is to keep this short and sweet. And maybe get you to an early lunch. We'll see how we do. So PTRCs have been around for a long time, and they're found nationwide. Arizona does have just the one Patent and Trademark Resource Center, which is where I am. The goal of it is to provide a local resource that helps disseminate the information about patent and trademarks and to help support the intellectual property needs of a community. The Patent and Trademark Resource Center is part of the State of Arizona Research Library, which is a branch of the Arizona State Library Archives and Public Records, which is a division of the Secretary of State's office. So it is part of our state government research library. So the way that it works is that the PTRC reps like myself are trained on how to use the search tools and understand the resources, and then we can turn around and help train you on what you need to know. So the Arizona PTRC celebrated its grand opening back on October 9th, 2013. They had a big event in the Arizona State Capitol building. Our office is no longer there. We're outside the Capitol complex. We share a building with the Arizona State Archives. So we're in the Polly Rosenbaum building at 1901 West Madison. So one of the things I wanted to make sure to cover today is the different ways that we can help you. And one of the first ways is that we can help answer questions. These kind of presentations, like the one that Jara gave, like the other ones that Maricopa SBDC have offered, give great overviews, helping people understand the distinctions between intellectual property options. But we're also here if you need some clarification, if you want to chat about it. We're librarians, and so our superpower isn't necessarily having all the answers, it's knowing where to find the answers. And so that's something that we can offer to you, and I'm happy to do so. Another thing that we offer is the ability to set up a virtual meeting with you. It's been very efficient and convenient to set up a Zoom meeting one-on-one and share our screen and kind of show and tell where to find the databases, how to create a search and view results. I will say that we always use generic examples. We're so glad that you have ideas and you have needs, but we really don't want to know any of the details. We want you to keep your, patent information, your ideas private and confidential, which is a really important part of the process, to make sure you're cautious about where you share what's in your head. And that said, though, if you're doing some historical research or you're just curious and you come to us with a patent number or the name of an inventor, we're happy to go into the databases and pull down the patent that you want to see, or pull down trademark information for you, and then show you how to do that yourself if you're interested. But that's something that we're happy to offer to you. If you ask us a question, what do you think about this or that? We won't be able to go very far with that because we really can't hear the details. We're librarians, not lawyers, so we can't advise you on whether something is patentable. We can't let you know whether you're infringing on someone else's trademark. We can direct you to those pro bono services that Jara mentioned. University of Arizona and ASU both have programs. The U of A has an Arizona Public Patent Program, as well as a law school clinic, and ASU has a law school clinic. And there are links to those services in the handout that you've received or will receive. We can also recommend where to look for patent practitioners and the directories that have that information, both nationally and in Arizona. Location is very important. We're the right place for a lot of different questions, but some things are outside of our realm of expertise. For instance, if you want to register your trademark in Arizona, but not nationally, which is an option, that's not handled by our office, but we are in the Secretary of State's realm, and their business services section handles that. So we could pass you off to that team for assistance. We do have some really exciting news for 2022 that I wanted to make sure you knew about, because there's so much information, so many things to know about patent and trademark research. We created 2 LibGuides or research guides where we tried to include links and examples and chunk the information in a way that would help you, go through that process. So those links are also in the handout. Since patent and trademarks are 2 very different paths, there are 2 different LibGuides, one for patents and one for trademarks. Jara mentioned this already. I'm very excited about Patent Public Search, which is the USPTO's new search tool. It went live on February 1st of this year, so it's very new for all of us. And we've been doing trainings, trying to learn how to use the system ourselves. Those other search tools, PatFT and AppFT, and the special ones, PubEast and PubWest, that were available on site in our library, I believe are going to get phased out over the next, I'm not sure exactly how long, but if patent searching is in your future, I think it's worth your while to get to know this new tool. The USPTO has put up training materials on site. On this site, you'll see the link in the lower right, and we are happy to go through it one-on-one with you as well and help show and tell how to use it. And you can do it from the comfort of your own home, which is wonderful. In our building, you're restricted and can't bring in your coffee. Even bring in a pen. We have a very restricted site because we share a site with the archives, but we'd be happy to show you how to use this from your own home. It's not completely set in stone yet, but it's almost there. We're going to have a full day of virtual programming with the USPTO. It will be in mid-September. We're aiming for September 14th. But I wanted to let you know that it's in the works, and it should be a really exciting event to cover a lot of the basics of patent and trademark searching, as well as having a local resource panel where you'll get to hear from people that can really help you understand more about what's available here locally. So, and hear different people's experiences. So I'm really excited about this. The USPTO have typically in the past done site visits where they've done this in person, but because of world circumstances, things have changed a bit, and the ability to have a virtual program, I think, makes this kind of event very accessible to everybody in Arizona, which is wonderful. We know not everybody lives in metropolitan Phoenix area. So if you're interested in attending that event, we would love to have you. It'll be free. It'll be full day, like I said, mid-September. You can keep an eye on our event calendar, and the link to that is in the handout. You might find some other things that we do that might be of interest to you. You can also send me a message if you want to be put on an email distribution list to find out more. The best way to contact me is to go through what we call our Ask a Question ticketing system. There's a link in the handout. You can see it here, but basically it takes you to an online form where you can tell us a little bit about what your needs are. And then somebody from our staff will reach out, depending on what the need is. So if you're looking for patent or trademark help, most likely I'll take over and contact you, and we'll talk about what your needs are. I also have a colleague, Janelle Breedveld, who also is a trained Ptrc rep, and she and I often will team up together to help patrons, because it's a lot of fun to talk about patents and trademarks. We're excited to provide that support. So you can use this link to ask any question you want about anything. If it's about patent and trademarks, we'll pick it up. And if you want to be added to an email distribution list, you could go this route as well. And I'll know what to do when you reach out. So I think, those are the big things that I'm really excited about. I'm really grateful to have been here to listen to Jara speak and be part of this event. And I know that there are some questions that were probably aimed towards Jara. If you have questions for me, some of those might be best handled offline, depending on how detailed and specific it is. But I will turn the time back to Lou. And again, glad to have been here with you today. Thanks, Lou.
Terrific. Kori, thank you so much. And it's, this is a fairly complex process, and having local resources made available both, online and virtually, and just knowing you behind, as a subject matter expert is really, really valuable for us here in Arizona. So thank you very much. I'm going to, let's see, I'm going to share I think we're going to try to tee up some questions. And I was hoping, Eileen, if you're still on there, if you could check the chat.
Yes.
Okay. We do have some limited time here, so do as many as we can, and then I'll close it up.
Perfect. We have the first question, which is, will this webinar be available later after the live stream for us to review at the later time? And yes, it will be. I can actually answer this. It will be available. I will be sending over a link for our YouTube channel, which has all of our recorded webinars, as well as the handout that was sent out earlier. And then another question that I have is, will the slide deck be available for us to check later? Yes, it will. It will also be sent out as well. Another question that I have is, how about IP protection for trade secrets? For example, non-patentable activities versus a device.
So I think that one's probably good for Jera.
Yeah, so for trade secrets, that would be something that you would have to, just sort of protect that knowledge, make sure that it's not being disclosed to the public, sort of protect that with only, people who really need to know within your organization. There's not a particular governmental register or anything like that for those. It's more based on your business practices.
Thank you, Jera. Another question that I have from Tony is it normal to sell a product while a patent is being worked on or being in process? What would be the risk versus its benefits?
Yeah, it is common. A lot of times you'll hear people say, patent pending, or you might even see that on, the product that's for sale. It'll say patent pending. What's important in the process is getting that date. So that's why when I was talking about provisional applications, one of the reasons people will file them, even though they're not ready, to file claims yet, is to get that priority date. So that means once you have that date established, if you are selling your product, as long as you file your non-provisional application within a year, you would have protection from the date you filed the provisional through the 20 years. And having that protection in place prevents someone else from then maybe seeing your product and then filing an application based on it to get protection because you haven't, filed anything yet. Because whoever's, sort of first to file that application, that's who would get the patent. So I'm sorry, did that answer the question?
I think you did. Yeah. Thank you, Jera.
Thank you, Jera. I have another question that says, as a packaged food company, we believe we might have a unique process for producing our granola. Is this something we can protect? How can we find out if any big players might already have something similar protected?
All right, so processes are definitely subject to patent protection, and so you would want to go through some of the steps that we talked about initially. You would want to search to see if there's information you can find. It's maybe a little more difficult with a process, right? A product, I mean, you can just look for something that's out there. For a process, you might look in journals, if there are journals for that industry, if there's educational institutions that focus on that industry. You could even look through dissertations, things like that, anything that you can find on the web where someone is talking about, their process for doing the same thing. So you'd want to just kind of get a feel of that industry and what information is out there and what might be used as, prior art that I was mentioning that might, sort of prevent you from getting a patent. But, a process like that is, in general, that is something that potentially could be protected with a patent.
Thank you. Another question is, if you have been using a name here in Arizona and did a trademark, can someone trademark that name after you have the trademark in Arizona?
I can answer a little bit about that if you'd like me to. So when you file for a trademark nationally, one of the steps in that process is to try and do due diligence and good research to see if the name that you're trying to trademark or the logo or whatever it is, whatever branding hasn't been used. You're not required to register a trademark nationally, but if you do, that gives you certain protections. So if somebody hasn't done their due diligence and you have a trademark in Arizona and somebody is infringing on your trademark, if you haven't filed nationally, that limits your options, but you're responsible for monitoring the use of your trademark. And another thing to think about is the trademarks depend on the class of goods and services that are claimed being attached to that trademark. So there's possibility that somebody could have a trademark similar to yours, but if it's a different class of goods and services, they might be able to still register it, and is it considered a likelihood of confusion? So there's several different things to consider, and you can watch for trademarks that are being published. The Trademark Office has a gazette that comes out, but I would think my answer would be that it's complicated. Jara, I don't know if you have anything to follow up on that.
No, that was great. Yeah.
Another question is, can an educational program be patent?
I'm not quite sure what that means. So when I think an educational program, I mean, that could have a lot of different components. If there is a certain method of how, I can I can start to make up some hypotheticals, but I think I'd have to know a little more about that. But just to keep in mind, the main categories that we talk about with patent protection are, a machine or an apparatus, a process, or a product of manufacture. So with educational programs, I can imagine there's some things that might be copyrighted if there's material that is used for instruction, that sort of thing. Patent protection, I'm not sure exactly what that entails to kind of answer that question.
Another question I guess I have is, patents are viewed by cynics as an invitation to copy if IP in general. Is the topic SB info beyond just patents? It's also on the Q&A. Confidentiality and non-disclosure agreements, for example.
So, I mean, as far as, how patents are viewed by cynics as an invitation to copy, the system is actually intended to protect those who have that original idea, that original invention, to, give them a time period of protection from, having others do the same thing. There are, we've all heard of, different lawsuits and things where people do what we call infringing, may infringe a patent. But generally speaking, the system is intended to provide that, certain time period where there's protection for the original inventor, and then, sort of hand that knowledge over to the public to use in general. One area where we probably can easily think of that is in pharmaceuticals. There may be a medication that for a while it's subject to patent protection, and then later we hear about a generic version of that medicine, right? So that happens usually when the patent term has run out, and now that knowledge is freely given to the public, and now anyone can manufacture that medication. So hopefully that answers that question.
Another question we have in the chat is, how long is the trademark process currently? I have heard there has been a surge in applications the past 2 years.
I think that's true. I believe it used to be around a year, but at this point it may be a little longer, maybe a year and a half.
Another question is, how about the name you give your proprietary process? How do you protect it? And this question is in the chat by Roseanne Higgins.
So that, go ahead.
Oh, I'm sorry, go ahead.
No, I was just going to say, you know, if you're trying to trademark a name of something, then that would, you know, needs to be attached to a class of goods and services. So then it would be the normal types of things that you would do to protect any trademark or trade name. But go ahead, Jara, what were you going to say?
The same, yeah, that sounds to me like it would be something that you would pursue trademark protection for.
Hey, Eileen, I'm watching the time here. I think we've got time probably for a couple more.
Okay. Another question is, how do you protect song co-authorship? Are there some sample agreements? Which office should I call first to follow up for these answers if needed?
So I believe we have some links to that. That again would be the Copyright Office, which I don't have an answer for that, but we can certainly get you some resources for the Copyright Office and information that they have about that.
Another question in the Q&A is, does data sovereignty have the potential to impact the patent process by lowering the entry level of acquiring a patent to original content? This is in the Q&A.
I'm going to defer to Jara on that one. I think that's outside my realm of expertise.
I'm afraid that's outside the realm of mine too. I mean, the office is certainly involved in, you know, some policy initiatives. I don't know if data sovereignty is one that, you know, we're looking into or working on, but I'm afraid that's a bit outside the scope of my expertise also.
Now, this will be the last question that I will be addressing. I submitted a trademark application in USPTO in January 2020. How long does it typically take before it will be assigned to an attorney for a review?
So the times have been getting a little longer, as someone mentioned. There's, you know, was kind of a surge. I believe it used to be around 3 to 6 months. So it may, you know, be maybe that time frame or a little longer.
All right, terrific. So Eileen, I think we'll cut the questions off at this point. and I'm sharing my screen. Can you see it?
Yes.
Okay, terrific. So again, thank you everybody for attending. I want to talk to you just a little bit more about the SBDC and kind of our role here, and how to engage us. So there's you can request counseling as a business. They are by appointment only. Typically, what happens, you're assigned a counselor. And when you do your request, put in kind of what you think you need, and they'll assign it based on expertise. So you'll have an initial counseling session, and the counselor will probably ask you a lot of questions and try to get to know you a little bit. And then there's usually regular follow-up sessions, and we meet with our clients one-on-one on a regular basis. And our goal really is your business goals. It's tracking your reporting your metrics. So what we really want to do, and how we want to affect your business, is growth. We really want you to succeed. We want you to hire more employees. We want you to be able to increase your sales. We want you to be able to get the capital that you need, etc. And that's kind of how we work with our clients. We're a no-fee service, again, picked up in advance by your taxpayer money. Most of our counselors are all ex-small business people or have some kind of expertise. So they're very relatable typically. I will tell you, I do mostly the technology commercialization. We've got another fella that actually has some expertise. With regard to patents, I'll say that, yeah, there are some pro bono resources, and there are resources available to the individual. But I got to say, in my experience, that they're having a good patent attorney, a relationship with a patent attorney at some point, is really, really valuable. It costs money, and when you come to us as the SBDC, we're business people, so we understand that money needs to be invested into a business, whether it's in a patent or other means, before the business can get going. And this is just one investment that you're going to have to make at some point. So we can also provide referrals to patent attorneys when it comes to that. But we like to first discuss with our clients, the business, the idea for the business, beyond just getting a patent approved or granted. There's some different business models, and so there's some things to think about. I think a lot of folks equate getting a patent with monetization, and money just pours in after you get your patent, and that doesn't necessarily work that way. It kind of pours out for a while before it starts to pour in, and there's a lot you got to do in the meantime to monetize it, and that's the business infrastructure around it. So that's all I've got for today. I think thank you for joining us. Any last remarks, Kori or Jera?
Thank you for the opportunity, and please, everybody, feel free to reach out, and I'm happy to talk one-on-one more and direct people to good resources. So thank you.
Same, thank you for the opportunity, and please visit us at uspto.gov.
Everybody, there'll be an evaluation sent at the end of the program. Eileen, will you send that via email?
Yes, I will.
Terrific. If you please fill that out and let us know how we did, we would certainly appreciate it. And again, thank you, Kori and Jera, for participating. Thank you, Eileen, and thank you, Julie.
Thank you, Juan. If you would like to request for no-cost business counseling, I have left the link below in the chat. And thank you all again. We hope you have a wonderful day.
Thank you.